என் அன்பு சகோதர சகோதரிகளே, எல்லாருக்கும் வணக்கம். Honorable Judges of Supreme Court, Chief Justice and other Judges of Madras High Court, I hope that within a near future it will be called Chennai High Court. We are honorably working on it. Other Chairman Bar Council of India and other office bearers, Chairman Bar Council of Tamil Nadu and Puducherry and other office bearers, dignitaries on the dais and off the dais, friends from media, ladies and gentlemen. Really, it is my immense pleasure and privilege for being with you on this occasion of Lawyers Meet 2015, organized by the Bar Council of India on a very important subject, public litigation policy and access to justice. I extend my greetings and good wishes to all the members of the Bar Association, Bar Council of India and Bar Council of Madras for having organized this great function wherein I am as a listener. I am not a person going to address the August gathering because honorable judges, I wanted to hear their views, hear their suggestions. As a minister, as an executive, it is my responsibility to implement the suggestions that is given by the honorable judges and other dignitaries on the dais. So practically several issues which was brought before this August meeting, and the issues that has been raised will certainly taken note of, and I don't assure that everything will be possible from my side, but I will try my best to see that certain suggestions which are given by the this August House by all the judges, Supreme Court judges, that will be taken care of by the Ministry of Law and Justice in the near future. I think you are all the key players in our ongoing determination to provide legal aid and access to justice to all citizens. I will not touch the area of that public litigation policy. I will touch the area of national litigation policy that is already ready with us, already interministerial consultations and suggestions from the stakeholders. Everything is ready with me. I am moving a cabinet note within 15 days, and National Litigation Policy 215 will come into force within a near future. I hope that it will give solutions to various issues that has been raised during this meeting. Access to justice should not be construed or understood to be reaching out in geographical terms. Access to justice means fair adjudication of disputes arising in the society, both through formal and alternative method of justice dispensation. Though the formal system of justice like courts, tribunals, etc. are available to a person when he is in need of fair resolution to a dispute or an issue, equally important are the traditional but fair systems of adjudication, which can either be peer groups, settlement of disputes by village elders, resolving the disputes at the village panchayats, or any other form of alternative dispute resolution, including mediation, conciliation, and arbitration, etc. I am very clear in my mind that the formal systems of justice dispensation consisting of courts, judges, and lawyers will never be able to meet the growing demands of justice dispensation in the vast country populated over 1,200 million of people. What is important is creating a society which has less disputes, a society which can resolve disputes through its own local mechanism in a fair manner. It is, if not possible, provide alternative dispute mechanism in alternative dispute resolution mechanisms in a formal or informal manner which costs less and provides quick resolution of the disputes. The point which I would like to make very strongly is that by talking about access to justice, if you mean that we are going to establish a court and provide a magistrate in each and every village, I think it is a wrong idea and not practically achievable, and it is not affordable also. Access to justice has another angle too, that is affordability. One may have plenty of something around him which he needs badly, but it is of no use if it is not affordable to him. A large section of our population are not economically well off. Their capacity to assess the justice dispensation system becomes limited. As a result, though a citizen of India is free to engage a best lawyer in the country to secure a favorable but a genuine result, he may not be, in reality, able to achieve that due to the cost factor. This is not the hypothetical situation, but the finding brought out by a research study conducted by the national university students, which brings out that 3/4 of those who have been given harsh punishment like death penalty belongs to economically and socially backward and weaker sections of the society. Though our justice dispensation system, in principle, is not a class-based system, the data brought out by the study hits very harshly at our face that in practice, due to various factors, especially the cost factor, our system may have come a class-based one. Now it is our duty to stand up to correct this anomaly, failing which it may result in miscarriage of justice. One of the fundamental factors brought out by this study is that of affordability. We all know that engaging a best lawyer, either at the High Court level or at the Supreme Court level, it is very costly proposition even for an upper middle class person. If that is the case, what will be the fate of more than 60% of the lower middle class and poor sections of the society? It is a question we ourselves to pose to our conscience. I am of the opinion that the subordinate courts also, if the system is not affordable for 60 to 70% of the population, can we say that we have achieved access to justice for all? Now, my friends, let me tell you, do we stand and where we stand and where we are heading to. This has to be thought of by the legal fraternity. I would also like to stress one thing very clearly, that this issue of affordability can never be tackled by the government, as this responsibility primarily depends upon all of us, that is especially this legal fraternity. Hence, I would only request all of you that if, as a reasonable citizen of the country, you want to ensure the access to justice to all our fellow citizens, you all need to think twice about the cost factor and how to do something about it. The better course of action would be to adopt 3 prolonged strategies to reduce the high-level litigation. 1, to avoid litigation. It may be a little bit difficult. Second, adopt alternative dispute resolution mechanism, which will be possible if we all think on those directions. Third, adjudicate quickly. Certainly it could be done, and as rightly put it by my honorable judge, if it is a time-bound disposal, a decision has to be taken by only the judges. They can do it, and certainly the advocates has to cooperate for all these things. Resorting to arbitration is an alternative dispute resolution mechanism, needs to be encouraged at every level. The alternative dispute resolution mechanisms are not only quicker in disposing of the disputes, but also bring down the pendency in the courts as well as the cost of litigation. If the bar and its members advise the clients to opt for alternative dispute resolution mechanisms, I am sure in the days to come, this will become popular. There are about 3 crore cases pending in various courts of our country. We are struggling to drop plan to clear the pendency. The Code of Civil Procedure was amended with a single point agenda to speed up the disposal of cases. Have we achieved it? Certainly not. The answer is no. If we have not achieved it, have we thought about why we have not? Where we have gone wrong? as the intention behind the amendment is noble and very close to the hearts of the people, we need to reflect on these issues and come up with solutions for obstacles in speeding up the disposal. Failure, in my opinion, to achieve the desired objective is because the stakeholders, you all and we all, have not owned it up. We have envisaged a national litigation policy 2015 to contain frivolous or unwarranted litigation by or against the government. As it is said by our Honorable Justice Nagappan and Chalameshwar, practically this will certainly give us some relief. That is our belief, and in this direction only we have worked on it. This will address the problem of increasing load on judicial system. The policy outlines mechanism to reduce filing of cases by or against the government. It aims at avoiding unwarranted litigation and making the government as an efficient and responsible litigant by having recourse interlay the alternative dispute resolution mechanism. So, my dear friends, better access to justice, avoiding litigation, and promoting alternative, cost-effective, and quicker justice dispensation are the challenges that the legal profession must face in order to better the delivery of justice. As officers of the court, legal professionals are critical stakeholders in the justice delivery system and shoulder great responsibility in the functioning of the vibrant democracy such as our country. In whatever steps are taken to further this ongoing effort of providing access to justice, particularly to those who need the most, you have the continued support and commitment of the government. One or two issues, especially Honorable Justice Kurian, he pointed out and he gave suggestions that the state of affairs of the subordinate courts across the country. Certainly, I welcome the suggestion. After assuming the charge as the Minister of Law and Justice, I visited about 6 high courts. But I certainly agree that I have not visited any of the subordinate courts. But it is known to all of us that the state governments are responsible for the infrastructure and all other activities that need to be carried. State government, in consultation with the Chief Justice of the High Court, they have to go ahead with all these things. But still, I will certainly, I will assure you that in the coming days, within 1 or 2 or 3 months, I will visit minimum 3 or 4 or 5 district courts or subordinate courts, and I will come back with a report what I observed there to the Honorable Justice Kurian. Certainly, if a central minister goes to a lower court, an official court or a subordinate court, certainly the state law minister will accompany me. Thereby, even the Chief Justice of that High Court also can be written with a letter requesting him, these are the needs of the hour and you should take care of the things. Certainly, I welcome your suggestion and I will take care of the things. Another issue that was raised by all the honorable judges is with regarding to the strengthening of bar associations of subordinate courts as well as the district courts. Of course, I will assure in this occasion that already the e-courts mission mode project phase 1 has been completed. The phase 2, we have already last week we took the approval of the cabinet for the phase 2 project for rupees 1,786 crores, wherein we wanted to have all digital libraries in almost all the courts across the country, where we have already taken initiation with regard to computerization, wherein we will get all the latest books, all the journals, judgment copies in the soft copy through the e-court project. So all the courts will be given proper library, which it is under phase 2 of the e-court project. With this, once again, I welcome all the suggestions given by the honorable judges and my advocate brothers, and I will see that to make the justice delivery system accessible to a common man to the best possible extent, what could be done by the government, central government. With these words, I conclude, and I once again thank the organizers and everyone for giving me this opportunity. Thank you, one and all.
Dhanyavadangalu, and thank you very much, sir. In Tamil, there is a famous quote, Manam irundal margam undu, which means where there is a will, there is a way.